SJC-13009, John W. Vazquez Diaz v. Commonwealth.
Do we have Attorney Kiley? Here she is.
Sorry about that. Here I am.
No problem. You can proceed.
Thank you. Good morning. Rebecca Kiley on behalf of John Vazquez Diaz, who sits currently at the Nashua Street Jail, held on cash bail and awaiting trial on a drug charge that carries a 12-year mandatory minimum sentence. Mr. Vazquez Diaz is before this court because he seeks a live in-court hearing on his critical motion to suppress evidence and statements, which could mean the difference between conviction and acquittal in this case. He's willing to wait for such a hearing until the court deems it safe to be held. But nonetheless, the motion judge ordered him to submit now to a Zoom hearing at which he would appear alone and with a remote interpreter from the jail. Even when the technology operates perfectly, and it often does not, a Zoom hearing is simply incapable of even approximating an in-court hearing. The judge's order, if carried out, would violate several of Mr. Vazquez Diaz's core constitutional rights, including the right to be present and to confront the witnesses against him. But this court need not reach
when you say he would be willing to wait, should we take that to mean that he would be willing to waive any claims of delay?
Yes, and he said that explicitly at the hearing before the motion judge. He acknowledged that this court has sort of handled the speedy trial, the Rule 36 speedy trial issue for him so far, but said to the extent that becomes an issue, we will waive our Rule 36 rights to a speedy trial in order to waive.
This question is not going to surprise you. As we all know, we're in the midst of a pandemic here. The Constitution is an organic document. We've got meet witnesses face to face as the language we're interpreting. We've got to infuse normative values into those open-ended provisions, recognizing the world we're living in right now. And when we take into account the private interest, Commonwealth's interest in the outcome and concerns about an erroneous deprivation in the midst of a pandemic, why aren't Zoom hearings constitutional? They're not optimal. Why aren't they constitutional?
Well, I think the key reason is because there's no compelling reason to rush to do this hearing in this case. And this, I really want to make clear, because the Commonwealth, in doing the Matthews v. Eldridge balancing test that you just alluded to, the Commonwealth attempts to put on one side of the scales the public safety and health risk that could be posed by holding the hearing currently. But it's not fair to do that where Mr. Vazquez Diaz has said, look, I understand that. I don't want to put anybody in jeopardy. I'm willing to wait. And what they haven't done is advance a compelling reason to rush this. They give two reasons, and I'd like to talk about why I think neither of them is sufficient here. The first is they talk about the backlog of cases.
Sorry, Ms. Kiley, before you get to that, can I ask you just a preliminary question?
Sure.
This case, when we rule in this case, it's going to impact all cases. And I understand Mr. Diaz's personal willingness to waive any speedy trial. What about other defendants, though? Would you have us rule that a Zoom hearing is only possible if there's a valid waiver? No fingers crossed for any other defendant?
Yes, I'm sorry, I feel like there were two parts of that question, but I think that a Zoom hearing is fine if a defendant waives his constitutional rights to be present and to confrontation. As for the speedy trial issue, as Justice Lowy just suggested, constitutional rights are not absolute, and sometimes one has to bend to another. So a defendant might have to sort of choose between his right to a speedy hearing and his right to an in-person hearing.
Does that waiver come into our due process balancing?
I'm not sure I understand in what way.
Because there are a bunch of constitutional provisions. One is confrontation clause,
right,
which is open-end, which is a yes or no.
Right.
But then we proceed to the due process issue. Because if it violates the confrontation clause, it violates the confrontation clause. But then if we proceed to the due process issue, is that when we take into account the willingness of a defendant to waive in balancing the government's interest.
Well, to waive a speedy trial, right?
Right.
Yes, exactly. And this is the point that I was alluding to, right? I don't think it's fair for the government to assert an interest in public safety and health when Mr. Vazquez Diaz isn't asking for a hearing that would, cause any danger in those respects because he's willing to wait. And so I think they're left with two interests. The first that they identify is the growing backlog of cases. And on that score, I want to say first that, Mr. Vazquez Diaz is not responsible for that backlog, and we shouldn't seek to solve that systemic problem on the backs of incarcerated indigent criminal defendants. But the second thing is that the holding the hearing in this case on the motion to suppress is not going to do much to clear that backlog. The Commonwealth cites the JMAC report in its brief, but on page 6 of the JMAC report, they make it clear that the thing causing the backlog is the fact that we can't have jury trials, and that the backlog is going to continue to grow until we can have jury trials. That's what's really clogging up the system here. The amicus brief, which I would commend to the court's attention for many reasons, but one thing that they say that I think is helpful here is they note evidence that only about 4 to 5% of criminal cases even involve a suppression hearing. So it's going to do very little. Even if this court were to say everybody's got to get on Zoom and do it on Zoom, it would do very little to solve the backlog problem.
Can you waive the constitutional right, Dr. V. Wingo, constitutional right to a speedy trial?
I am not aware of any reason that the defendant can't waive any of his constitutional rights. I mean, he defendants routinely waive their right to a trial. So I think
don't we
yes.
Don't we just treat it like a continuance? You've requested a continuance, so we just deduct the time from the.
Sure, right. I mean, I think that's right under the Rule 36 calculation that this time, cannot count against the Commonwealth.
Can I ask about the practicalities if you have a right to confrontation here? So
Sure.
We haven't decided whether you have a confrontation right.
That's right.
For motions to suppress. Fontanez leaves that open. So how would it work? How would hearsay, if the right to confrontation applies here, how do we analyze hearsay? What type of hearsay is going to be permissible? And if we agree with you that the right to confrontation applies here, I'd like to understand the practicalities of.
Well, I think that everybody has been proceeding on the assumption that the right to confrontation applies at a suppression hearing. And I understand that that is an open question, as the court said in Fontanez. But I don't think it would change anything about the way that we currently practice. I think the dramatic change would come if the court endorsed the Commonwealth's view that there is no right to confrontation.
But isn't there how do it hearsay? Because hearsay, hearsay is a big part of motions to suppress.
Well, I think hearsay is permitted at motions to suppress to the extent that the testifying officers were permitted to rely on hearsay to reach their probable cause or reasonable suspicion determinations. And we don't dispute that can continue to be true, right? If the police see what they think is a hand-to-hand transaction and the buyer tells them, I bought the drugs from that guy, the officer can testify to that at the hearing, and it's not a constitutional confrontation problem because he can be cross-examined about it. But what the Commonwealth is suggesting is a regime where, and I know they're saying they wouldn't do this, but that's kind of cold comfort here. They're suggesting a regime where there's no confrontation right at all. And
what about the informants and the other stuff that appears in warrants all the time?
Well, we're talking about an evidentiary hearing with witness testimony, which is not a search warrant hearing. I don't think there would be a problem with having a four corners hearing on a search warrant, on the sufficiency of a search warrant affidavit.
Would you agree if you had a search warrant case rather than an evidentiary hearing case, you would have no trouble with the oral argument part of the motion being held on Zoom? Is that right?
I would agree with that, yes. And in fact, if the judge in this case wanted to bifurcate the argument portion of the hearing from the testimonial part and do the argument part on Zoom, I don't think we would object to that either. I would prefer to be in court in front of you all right now. It's a little harder to read the room this way, but it's not, I think it's okay for this purpose.
Well, we all recognize, so go ahead, Judge Lowy.
Yeah. Can I ask one other question about what we're comparing to? Because your brief compares, the Zoom hearing to trials in the old days. When we don't, I mean, we have now, if we're in court, we've got masks, we've got distancing. I'm not sure Zoom is worse by comparison to the current courtroom setup as it is, you know, and you're comparing to the old days. We're not in those old days anymore. What do we compare when we determine whether there's a violation? Court as it is now or court as it was before COVID?
Well, I think it's fair to compare it to what would happen if we were in court, but I'm not sure. I don't know that the fact that participants will be wearing masks is going to make such a substantial difference as compared to.
Oh, can I stop you there, counsel? I mean, of course it would make a difference because you wouldn't be able to see facial expressions, which I thought was part of your analysis on why Zoom is inefficient.
Sorry, yes. I mean, I think if the judge is wearing a mask or the defendant is wearing a mask, I'm not sure that that makes a huge difference.
But let's put a mask on the witness. That's what would be required.
Well,
Does that make a difference?
My understanding from the JMAC report is that the recommendation is that the witness, while testifying, be sort of extra distanced from the other participants with an air filter next to them so that they can take the mask off when they testify. But I think, I think it's important to understand that looking at thumbnail images on a screen, and possibly a screen this size, right? The defendant is in Nashua Street, so he's going to get a laptop. But if he were to bail out, he would participate in his evidentiary hearing on a critical motion to suppress evidence on a smartphone. And the idea that that can in any way approximate an in-court hearing, I think just sort of defies common sense.
But can I push you on that? Because you've said that several times in your brief, and I want to know why. What defies common sense about the concept that on a laptop from a jailhouse, the defendant is not given something that approximates a courtroom?
I think there are several responses, so I'll try to go through them with the remaining time. But for one thing, I think the gravitas and solemnity of the proceedings is lost when it happens. You could imagine a witness who's sitting in the comfort of their own home, perhaps on their couch, on their phone, offering testimony. I think that feels very different than being in a courtroom next to a judge in the witness chair. But it also, and of course, the defendant's ability as he watches the proceedings to actually discern reactions is much different if he's looking at what we call a thumbnail image, as opposed to a live person in front of him, where you can perceive the fidgeting and the nervous tics and the facial expressions in a way that I just don't think you can on Zoom.
But why not? I guess that's my question.
Well, partly, right now,
you say these things in your brief, but I don't know that there is a basis for that. I can tell right now, who's moving, what the fidgeting is, your facial expressions. Why is that not enough?
Well,
why doesn't it sufficiently approximate given the pandemic nature of what we're at?
Well, first of all, I think when it comes to the confrontation right, approximation is not sufficient. But you can't tell
But we haven't decided the confrontation right yet, right?
Right. So, but if I could just go back to the difference between Zoom. You can't tell if I'm tapping my toes right now. You don't know if I'm twiddling my pencil or fiddling my thumbs. And you would if we were in court.
You're saying the Constitution requires that I see your tapping toe?
I'm just saying that you don't have the same opportunity to observe the witness's demeanor as you would.
Right, but you just said that all these constitutional rights are not absolute. So I'm wondering what part of the Constitution requires the tapping toe?
So this court recognized this problem with respect to the confrontation problem in Bergstrom, right? And I think a key issue here is that, and again, I'm assuming now, and I hope that the court is going to decide that the Article 12 confrontation right applies as I talk about this. But our Article 12 confrontation right guarantees the right to face-to-face confrontation. And that is because there is a deeply held belief that it is more difficult to lie when you're facing the person you're accusing. That's particularly true in a suppression hearing where the defendant is a recipient witness to the events. And the witness knows, if I tell a lie about this, the person in front of me is going to know it. That's very different in a Zoom proceeding where the witness never has to look at the defendant, right? Where we can't make eye contact. I am looking at my webcam right now and I'm trying to convey to you the impression that I'm looking at you, but in fact, I'm not looking at any of you. And I don't have to. I can do this whole argument without looking at any of your faces, right? And what our courts have said, what the appeals court I think said rather eloquently, is that any proceeding that allows a witness to testify naturally and comfortably without ever looking at the defendant and without the fact finder having any idea that they're not looking at the defendant, which is true in Zoom, that just doesn't suffice. Another constitutional issue, I think, is the impaired communication between client and attorney during a hearing, right? And this is especially critical, again, because the defendant is a percipient witness, right? So
Well,
he has really important.
Let me push you on that one, because again, the new world versus the old world. Right now, in the new world, you're not sitting next to your client, right?
Actually, that's not what I've heard. The reports that I've heard from trial attorneys is that they are sitting next to their clients. They're not. And I think there's sometimes glass on the table between them. But
we're spending a lot of time trying to get this technology that the federal courts have, which allow these kinds of sort of conversations between the defendant and the defense counsel. But you're telling me basically in the real world, we're actually sitting next to each other still. Okay.
But along those lines, Justice Kafka, may I interrupt for a minute with
Go ahead.
Attorney Kiley, do you agree with the fact findings or the descriptions, not the legal conclusions, but the findings that the Judge Ames made with regard to how that Zoom system worked for the hearing?
You know, I'm not sure that, I think it's true that there were no obvious technical gaffes during that hearing. I take some issue with Judge Ames' conclusion that she could tell that the defendant was understanding the proceedings, because I'm not sure.
Well, putting aside her conclusions, just her description of the hearing, her description of how Zoom worked, anything wrong with how she described all that?
Well, I think that she failed to recognize the problems that I just talked about the eye-to-eye contact. And
right, and again, I'm just talking about the mechanics, basically. Did she get the mechanics right?
Well, right, I'm sorry, I guess I regarded that as a mechanical issue. Right, the limitations of Zoom in terms of eye contact. I right now, nothing is coming to mind as a particular.
But I get back to the communications with counsel, because that is without doubt a critically important issue. But when we think about due process and the flexibility of it, we look at Abbott A, for instance. In Abbott A, it's a 58A hearing. The defendant is incompetent. By definition, the defendant can't have a meaningful dialogue with counsel, and yet we find there's no due process violation. So this is not to dismiss the importance of that communication. It's critical. It's to make the point that we have to recognize the world we're in, and there are really no absolutes.
Right. And again, I think that what he's asking for here is fairly modest, right? He'd just like to wait until it's safe to do this. And he's the one who's sitting in jail waiting for that, right?
Hey, can I ask you about the other governmental interest? Do you recognize that there's a governmental interest that the Commonwealth might have in having the cases proceed in the system? I know you say it's 4%, but if someone's family member was murdered, there was an article in the Herald, I think yesterday, about a family member who's waiting for a murder trial. Isn't that a governmental interest we should take into account?
I agree that the government has an interest in moving the case along, and although I think it's important to note, you know, we could have this hearing by Zoom tomorrow, and he's still not going to have a jury trial until, well, at this point we're saying January, but who knows, right? But I think the other thing that's worth noting here is that the government has suggested that they need to move their cases forward because they can deteriorate. But they haven't articulated any reason to expect that's going to happen in this case anytime soon. Their witnesses are police witnesses. They have custody of the physical evidence.
But again, I know you represent Mr. Diaz, but we have to think about this rule as applied to every Mr. Diaz, correct?
Right, and that's where I think it's not going to do much for the backlog, because as I suggested, it's only 4 to 5% of cases. Also because, as we noted in our brief, a lot of these hearings did take place in the last few months in person, right? And
let me ask you something. Is CPCS telling their attorneys not to agree to this, or is there a rule that's coming out of your office, or is this something left to the individual attorney and or client?
the individual attorney and their client, because there are cases, I think particularly cases where the key issue is not going to be witness credibility, where a defendant might really want to get his hearing as soon as possible and be willing to do it
And
by
I
Zoom.
know CPCS has certain performance standards that its staff attorneys and people that take appointed cases have to comply with. Is this one of them?
They have to object to a Zoom hearing?
Right.
No, again, because you have to decide it based on the individual interests of the client. And some clients, you know, if you have a case where it's really just going to be a legal issue, everybody agrees that the police did what they say they did, we're just deciding was that legal or not, you may well want to have that argument on Zoom. But when the issue is credibility and the fact finder can't be in the courtroom with the witness, that's when I think we run into this real challenge. And that's why Mr. Vazquez Diaz wants his day in court.
But to your knowledge, is there a uniform policy or not?
No, the policy is always to do what's in the best interest of the client. I think the policy that there is, and I don't know the details of this, is that if you have a client who wants an in-court proceeding and the lawyer is not comfortable with that, then I think they have to try to find that client a different lawyer so that, that the client can have their interests vindicated. But if the client wants to have a Zoom hearing, then by all means, you know, that can happen. And that's one other way that we might deal with this backlog, is to try to identify those cases, right? What are the cases where everybody is okay with just saying, like, let's go ahead and do this by Zoom, and let's start with those.
Can I ask a variation on a question Justice Gaziano asked, and he may have been, how do we deal with this in the context of sort of release from jail pending trial? Now, we've got people, you know, your client's incarcerated. You know, we're trying to move this case along. We're not. The Commonwealth is trying to move the case along, but your client wants this in-person hearing. How does this play out in a request to be, you know, let out of jail at this point? How does that work? Do we take that into account at all? Does it have any role?
Well, I think, and I may be thinking of a single justice order, but I think it would be fair to argue that, you know, the delays occasioned by the pandemic are a changed circumstance. That
Right, but I understand that, but so the Commonwealth is trying to move the case along through this alternative procedure, but your client is comfortable with the delay in terms of speedy trial. But say the client is also pushing the single justice session to be let out. You know, your client's being held on $25,000 bail or something to that effect. I can't remember.
He is.
So say I want the bail amount removed because there's not going to be any proceeding anytime soon. Do we take this into account or no?
Well, I take into account that he's objected to a Zoom hearing.
Well, I guess it's how do you balance all these different competing rights and interests, including we've got court officers who are going to be right next to the defendant.
Right.
We've got other prisoners in jail. If the person wants an in-person hearing, may be exposed to the court office. I mean, there's just a lot swirling around. And one of the things your client's going to have an interest in is getting out of jail pending final resolution of this.
Right.
How do we take this issue into account in that calculation?
Well, again, he doesn't want to have the hearing until it's safe, so he doesn't want to expose court officers or other inmates. I suppose that a judge, I mean, I guess if he moves again to lower his bail because of the changed circumstance that he hasn't been able to move the case along, I guess a judge could say, well, you refused a Zoom hearing, so that's your fault and I'm not going to. I would certainly argue against that if that happened, in part because, again, you know, the real backlog here is the fact that we can't have jury trials. And that's going to be true even if he submits to a Zoom hearing. So, you know, yes, I think the longer that the pandemic goes on, the stronger the argument becomes that it's a changed circumstance for bail considerations. But that's not really, I don't think, directly presented by this case. And I know I'm over my time, but I would like to just spend a minute explaining the importance of the suppression hearing in general, because I think this is, if that's a...
No, everybody, we understand the importance, you know, that your client places on the suppression hearing, and so please rest assured that we get that. We're well past time, so I'm going to ask Ms. Campbell to present.
Thank you, Your Honor. Good morning, and may it please the court, Kaylin Campbell on behalf of the Commonwealth. I'd first like to start by acknowledging Kathleen Celio, the motion prosecutor in this case, and Shane O'Sullivan, who helped me to write this brief. On March 19th, the late Chief Justice Gantz wrote a letter to the bar and asked us to work together, and I quote, "to find new ways to protect the most vulnerable, preserve individual rights, resolve disputes, and somehow keep the wheels of justice turning during this frightening pandemic. Conducting pretrial criminal motions virtually is one of these new ways, and something that must be done to keep the wheels of justice turning, despite an ever-increasing number of COVID cases. Indeed, as the trial court recognized just this past Friday, additional measures have to be taken to limit in-person court appearances and do what we all can to stop the spread of COVID-19. Cases from this court, including the Bergstrom case, have recognized that traditional formalities of court are not necessarily an integral part of protected constitutional rights. And a virtual hearing over Zoom protects the core guarantees of each of the constitutional violations the defendant claims."
But
And I
Attorney
want-
Campbell, yeah, before we go forward further with that, doesn't it make a difference when the defendant says that he's willing to wait? He's okay with not having his day in court with regard to the suppression hearing until everyone feels safe, including himself?
I don't believe so. And I don't believe so because I think that gets to the Matthews due process type of balancing. And sure, that is an interest of the defendant. Before I get into the due process balancing answer, I think that though that may be a waiver in terms of one, that doesn't protect us against a later ineffective assistance of counsel claim down the line that says, hey, my counsel didn't tell me that I could be sitting in jail for this long, and that if I didn't have my motion adjudicated at this date, it meant that, and this is what we've been told in Suffolk Superior Court, that the cases that have dispositive and important pretrial motions will be at the very back of the line for jury trials once jury trials set back up. So I hear you, but
Is that something that could be worked out though with a comprehensive waiver? I don't see that as being a bar to giving the defendant what he wants here.
Well, while it couldn't be a bar, I think I would caution the court to consider that likelihood when crafting any rule that they craft. I also think that it doesn't take into account the substantial other interests that are at play. And it's not just the efficient administration of justice, which my sister points to solely as the Commonwealth's interest here. We have a constitutional right. The Commonwealth has a constitutional right to move cases forward under constitutional speedy trial rights. And not only that, it's harder for the Commonwealth, and the Commonwealth is prejudiced the older its case gets to prove it at trial. But additionally, the Victims' Bill of Rights ensures prompt disposition of criminal cases for cases involving victims. And there's also an interest in trying to ensure the safety of our community and that they see that dispositions of cases are happening.
You lose unless we find there's no confrontation clause, right, in a motion to suppress, correct?
I don't believe so. I don't think you have to go that far. I think you can find that there's a relaxed confrontation right under Article 12.
Well, how is Article 12 relaxed? Article 12 is more strict than the federal constitutional right. I know because I lost Johnson. It's face to face.
It is face to face. It's face to face. Every single case, though, that talks about this face to face requirement says it's face to face at trial. And there is no case.
You're begging the question because that's where I started. If we find that the confrontation clause right does not apply to trials, then we can proceed to due process what you're addressing. But until we do that, you're kind of stuck with the Article 12 face-to-face.
So I think Article 12 face-to-face is really the hardest issue that has to be sort of undertaken in this case, and the one that really needs to be dealt with, I agree, at the outset with you, Justice Gaziano.
Because you either have a confrontation clause right or you don't. And if you do have a confrontation clause right, you have a right to face-to-face under Article 12, correct?
Well, you have a right to face-to-face. I think it depends on what the definition of face-to-face is, right? I disagree with my sister with a lot of the factual assertions that are made in her brief about the observation.
Well, this court, involving the child abuse cases, really shied away from the federal model, correct?
Correct. However, if you look at those child abuse cases, what you're dealing with is very different technology than is at play here. And I think it is important to compare and contrast what happens at a trial as compared to what happens at a motion to suppress hearing. Because at a trial, it's the jury who's the fact finder and they have no control over the video conferencing that's happening. Here, it's the judge that's the fact finder, and the judge, as Judge Ames found in her decision, she is the one who has control. So a lot of the—
So you're arguing for Confrontation Clause light for motions to suppress?
Yes, and I would say that there could be a different definition of face-to-face, that face-to-face in all practical meaning of what that could mean is satisfied by Zoom. But
cases that recognize the so-called Confrontation Clause light?
I'm sorry, I didn't hear the first part of that question.
Are there any cases that recognize this novel Confrontation Clause light that you're proposing?
No, but the case law recognizes that no constitutional right is absolute. And it can yield to compelling interest. So insofar as we're saying it should yield to the compelling interest presented by COVID-19 and the extreme risk it has for health and safety of the individuals of those involved, that yes, a constitutional right in balance with that interest could yield to provide an Article 12 light type a situation.
But we don't have to do that. Sorry, just Scott, are you done?
No, I think either you have a Confrontation Clause right or you don't. If you don't have one, then you can proceed to the rest of the analysis. But go ahead, Justice Kafker.
So and I agree, we don't have constitutional rights have to give way to each other, but we don't have to make that choice, at least in this case, because Ms. Kiley is not, she's recognizing that we treat this like a continuance. Mm-hmm. So we don't have a speedy trial. We're not backing up against the speedy trial rights. And we're not forced into this choice between competing constitutional rights unless you force us into it. So why should we do that in a case that we don't have to?
Well, I guess my answer to that would be twofold. The first is the Commonwealth doesn't know of any other instance. The judge in this instance decided that a continuance would not be appropriate. So the question would be whether Judge Ames abused her discretion in making that call. Now, certainly that brings you into the constitutional analysis necessarily, so it has to be reached. Mm-hmm. But I don't think that it can be downplayed that the substantial and compelling interest that the Commonwealth has in moving its cases forward, not just because of efficiency, but because of the extreme difficulty, and in a post-conviction context, this is recognized, that delay has on a Commonwealth, delay has.
But does that really work as a practical matter in the real world? Because we got plenty of cases out there. Mm-hmm. It's not like we don't have enough courtrooms right now where we can hold live hearings. So if we've got people who don't want to do this, can't we look for someone who does? I'm just, the big picture, I don't know if you're speeding much along here.
Your Honor, to answer that question, the Commonwealth has not found many defendants who are willing to do so. And I'd say without guidance and a holding from the court that it would be constitutional to do so, many will be reluctant to actually do so.
But aren't we going to then get the case where someone is trying to have all their rights at once exercised in COVID? This case, we're not forced into that choice, but why don't we wait? If someone's saying, let me out, don't deduct from my speedy trial time, and I refuse to go into this, Zoom hearing, that's a different case, isn't it, for us?
That it is a different case. I suggest that you don't wait until that case. We didn't get to choose which case got brought up here. This defendant filed this 211-3. And I would say that as anyone, and you all have been sitting as single justice, it's been pure chaos as to what's been happening in the courts below. Right. It's been exceptionally difficult to even get judges to follow explicit standing orders, which state that people should not be having in-person hearings. So to say that the lower courts need guidance and that this should be happening as that virtual hearings, as it should be told to the lower court judges that not only are they constitutional, but they should be happening uniformly. One of the problems that we have is that there seems to be wide variety in judges that are willing to use this technology at all. And in some courts, it varies by even judges that happen to be sitting in that session. So there absolutely needs to be indication and guidance from above as to A, this technology should be used, and B, that it's entirely constitutional that it should be used. Now, the Commonwealth is not saying
Can I
that.
ask one other question, Ms. Campbell? And we don't have an evidentiary record on this, but the briefs include a bunch of these studies that outcomes of these virtual hearings, at least in the immigration context and in the bail context, that there's a weird effect of having this done by remotely. And that's concerning if that's true. And so do we not have is there a potential that you're more likely to lose in this virtual world, at least according to these studies? And these are some distinguished professors who've done them. The Diamond study, she's the one of the premier people on jury trials in the country. So how do we deal with that uncertainty?
Sure. I'm reluctant to say yes because of it wasn't subject to cross-examination and evidence wasn't taken onto it. So I'd say there isn't a developed record to draw that conclusion. But I do hear Your Honor, and it's not the Commonwealth's contention that these hearings should take place totally and forever, that suppression hearings should be virtually. It's, the Commonwealth is alleging that, not alleging, but the Commonwealth is suggesting that this court permit these type of hearings in limited circumstances and that certain factors need to be met. The first factor that the judge has to find is that there's a compelling need, which COVID would present. And so it would only be in the instances in which there is a compelling need. And I'd state that, if the language in any of the Sixth Amendment or Article 12 cases, which recognize that these rights are not absolute and that they can yield to compelling circumstances, are to mean anything, then certainly a global pandemic in which the gathering of individuals in a small space, which a suppression hearing necessarily would be, should constitute such a compelling need.
But when the defendant waives that speedy trial right, why is that compelling need that you identified the right compelling need?
Sure, and certainly it is a harder argument for me to make when a defendant is stating that. I think that that is only but one factor that needs to be considered in the whole variety of factors which the Commonwealth started to go down. And I think I finished off with the Victims' Bill of Rights, but that's just one competing factor that needs to be analyzed with a whole host.
But in this case, is the Victims' Bill of Rights at play?
It's not, but
okay, so no compelling need on the pandemic front, no Victim Bill of Rights. What applies to this case?
Sure, what applies to this case is the efficient administration of justice, because I disagree with my sister that the backlog is just going to be jury trials. Suppression motions happen in so many cases, and there will be a backlog of suppression motions if they are required to be in person in every single court. It is.
Where is that in the record?
Where is that in the record? I think it's just shown by the very nature of this case itself. This case was arraigned in May of 2019. His motion to suppress was filed over a year ago in November of 2019, and there's yet to be a hearing in this case. I think this case is indicative of what's happening in courts across the Commonwealth, because there is no mechanism by which there has been from this court stating that holding evidentiary hearings over Zoom is an appropriate way to go forward. There were a lot of questions asked of Attorney Kiley as to whether these are happening in cases, whether CPCS has a policy by which they object to evidentiary hearings over Zoom. And I can at least say in Suffolk County's experience, hardly any. I think maybe one or two have gone forward in that time, and certainly that is not.
Counsel, Attorney Campbell, can I ask you the same question I asked Attorney Kiley, and that is of Judge Ames's findings, not her conclusions, but her findings and how she described the Zoom process and the hearing process. Is there anything in there that's inaccurate?
No, Your Honor.
Okay. And then my other question is, when you get to this face-to-face, as Attorney Kiley's saying, she can argue to the Zoom camera and not make direct eye contact. To what extent does that exact eye contact matter in that confrontation issue?
I don't think it does. And again, it's hard. This case doesn't fit in neatly with the cases that exist because they're talking about eye contact and they're talking about demeanor in the context of a trial, which is they're talking about a witness being in a witness box before jurors, whether it's 6 or 12, and the juror's ability to be able to see that witness's demeanor, to see if he makes eye contact, to see any of those things. Now, certainly, Zoom, if a judge doesn't have a good enough view of a person via Zoom, she could ask them to move back, to move forward, to speak louder, to turn up their volume. If I were to look down and start reading, you could see that I was looking down to start reading. There could be questions that were asked about who was in the room or what was going on that would really allay some of the concerns that my sister raises in her brief. So
This is the police officer looking at the defendant and saying he consented to the search. That's the eye to eye, correct?
Yes.
But is that, when you do that, consistent with Bergstrom? Bergstrom says, we're watching the defendant's reaction. We're watching how the police officer, so in Justice Gaziano's fact statement, isn't the judge looking at both the defendant and the police officer when making that credibility finding? And the judge can't do it as easily on Zoom because they're not looking at each other. The judge is looking at thumbnails too. It's hard to do, right? And particularly in light of the language in Bergstrom, which was pretty specific.
Bergstrom is specific, but Bergstrom is very specific to trials. And a lot of what Bergstrom is talking about is the inherent limitations with the type of video that was used. In that case, it was a closed circuit television.
And,
that
that closed circuit television was not, that prevented the child witness from being in the same room with the defendant?
Yes, and not only that, there was a view, so they couldn't see the view of the child. That was the purpose, Your Honor. And the view of the child witness wasn't that great, and there were problems with color. There seemed to be distortions, and that's a case.
Let me ask you, Ms. Campbell, this hypothetical then. Let's say during COVID, there's a jury waived child rape case. We've got Commonwealth versus Amaral in mind and the enhanced confrontation clause protections under the Declaration of Rights. Jury waived trial and the child witness is going to testify via Zoom because of COVID. Is that a confrontation clause violation?
It could be, And I think the difference there is the difference between what is being discerned at trial and what's being discerned at a motion to suppress. At trial, it's recognized that the fact finder is determining an individual's innocence or guilt. At motion to suppress, it's a very different type of calculation that the judge is trying to determine. Is whether a particular set of actions met a legal standard. So I'd say it's qualitatively and necessarily different.
But isn't it really very similar in that the judge is just trying to evaluate the credibility of the witness in front of her?
That's true. You know, I hadn't thought of it in terms of a bench trial. There's something that gives me pause due to the difference in what's being decided. Ultimately, the ultimate decision that a judge is making as a bench trial as opposed to a motion to suppress. And also, when you think of a right to confrontation to a motion to suppress, though this court has never recognized that there is a right to confrontation, in the evidentiary hearing itself, there are relaxed evidentiary rules. So hearsay routinely gets in. So there already is recognized this relaxed standard that exists in a motion to suppress that seems to suggest that whatever right of confrontation that you have, if you have one at all, it is a relaxed right of confrontation.
But wouldn't your sister's argument rather, almost turn that on its head, and we'd have to start re-examining our hearsay conclusions about what we're letting in? Because now we're finding more of a confrontation right in these motions to suppress. So that relaxed standard might not be a good standard to apply.
I disagree. I disagree insofar as I think that's a standard that's already being applied. If you look at what's being applied and you look at I agree with my sister as to the types of hearsay that routinely get in at a motion to suppress hearing. So with this relaxed standard, I don't think it would necessarily change the evidence that comes in.
It's not hearsay anyway. It's offered to understand what the police officer's knowledge was.
It is. It is.
So it's not offered for its truth. It's offered to understand the information that the officer acted upon.
Sometimes
So,
though.
I'm not sure I understand that. Why wouldn't it be offered for the truth? The cop's testimony at the motion to suppress hearing, why isn't it offered for the truth?
Well, if the officer is talking about what the buyer said happened with the seller, that's offered so that the officer can calibrate probable cause. And even if it's not true, it calibrates into probable cause.
Everybody all set? Okay. Thank you so much.
Thank
counsel.
you.